just one moment. Did you adjust this?
No.
No, I couldn't. Do sit down. I should have done this. Yes. I think I put up with it this morning. I will continue to put up with it now. I'm sorry, it's my fault for not having it fixed too much. Yes, I'm sorry you managed to get something to eat, did you, despite the truncated break?
We did one.
Yes.
My Lord, what I propose to do is to start by setting out briefly why this issue arises for this court, and then to summarise the arguments that we will make on the issues on the appeal. But firstly, in terms of why the issue arises, might I just take your Lordships to the core bundle and to the Secretary of State's detailed grounds of defence, which begin in my copy at page 57, I think in yours at page 70.
Yep.
And if your Lordships would turn to page, what I think will be page 73 of your Lordship's bundle, with paragraph 16 at the bottom of the page. So, and under the rubric summary of the defendant's position, at paragraph 16, the Secretary of State said, the defendant can confirm, in response to the claimant's request for information, that her understanding when framing paragraph B, pausing there, that is paragraph B of the definition of a person with a Zambrano right to reside in the Appendix EU to the immigration laws, was that a person did not, if they had leave to remain under another provision, enjoy also a Regulation 16(5) right to remain. And then your Lordships will see the footnote at the bottom. Nor in the Home Office's view does a person without leave, but who qualifies for leave under a different route under the immigration rules, have a Zambrano right. See the policy guidance to this effect, and if needs be, I can take the Lordships to the policy guidance. So it was that evidence in the detailed grounds of evidence that showed the High Court that when making her policy decision about paragraph B in the rules, she had acted on a particular understanding of the regulations. And therefore it was accepted below that if she had misdirected herself in law as to the correct meaning of the regulations, she had erred in law in making that paragraph. As my learned friends point out in their skeleton, it doesn't follow that she can't reconsider, make different rules on the basis of a correct understanding of Regulation 16. But the case before Mr. Justice Mostyn proceeded on the basis that if the Secretary of State had misdirected herself in law about Regulation 16, then she had erred in law in making paragraph B. And there was a second consequence of that, of the Secretary of State's position on this, which was now that Regulation 16(5), as your Lordships will see, does not confer any right to reside where a person has or would qualify for leave under a different provision. And that was that whether or not she had made a formal decision on this in the decision on Miss Akinsanya's case, her position was that Miss Akinsanya did not meet the requirements of paragraph A of the definition of Zambrano person either, because she did not meet the requirements of Regulation 16(5). Just to take your Lordships back to...
I'm being slow. Why not?
Well, can I just show your Lordships paragraph, the definition of person with a Zambrano right to reside, which is divider 4 of the authorities. And more specifically at page 61 of that one. Your Lordships will see, my friend took you to it this morning, the term person with a Zambrano right to reside is defined, and the crucial words here are that at the end of that first paragraph, just before the colon, they were resident for a continuous qualifying period in the UK with a derivative right to reside by virtue of Regulation 16.1 of the EEA regulations, by satisfying, one, the criterion in paragraph 1A of that regulation, that is that they were not an exempt person, and two, either of the criteria in, and then the relevant one here is paragraph 5 of Regulation 16. And then we see at the bottom paragraph B, just to recap, Secretary of State, it's accepted that the claimant did not meet the condition in paragraph B, but the Secretary of State accepts that she made B on the understanding that a person who could have leave to enter or remain would not qualify under AA. In other words, it is out of abundant caution or a short-cutting measure that allows her staff to say, oh, well, you have leave to remain for part or all of that period, you don't qualify. I don't need to look at these other provisions. That's the way the Secretary of State, that is the Secretary of State's evidence in the detailed grounds of defence as to the basis upon which she made this rule. Now, that isn't, as my learned friend accepted in...
Hang on one second. Yes, because the job's already done by element A little Roman 2 AA. Sorry, A little Roman 2 1. So one more time. A little Roman 1, because the criterion in paragraph 1A is not exempt, and that brings in. Is that right?
No, so
I misunderstood.
No, I mean, what it means is that B is otiose, strictly speaking.
Well, that's what why is it otiose?
It's otiose on the Secretary of State's interpretation.
Yeah.
Because on her interpretation, a person can never meet the criterion in A Roman 2 if they had, for a period when they did have leave to enter or remain. Because
am I being slow? Isn't the otiosity because of A little Roman 1? No, I'm sure you're right. You thought about it.
No, because A little Roman 1 is only for people with indefinite leave to remain, another right to reside. So Roman 1 is exempt persons. It's Roman 2 AA that refers to the definition of the Zambrano carer, paragraph 5 of Regulation 16. And one might, before we began this litigation, one response that we had anticipated but we were wrong was that the Secretary of State would say, well, I agree with you about the meaning of the Zambrano right, but I don't want those people to qualify under this rule. That's why I've put in B.
Yeah.
But she didn't say that. She said, I disagree with you about the meaning of the Zambrano right. If they have any leave to enter or remain in that period, or as you've seen from the detailed grounds of defence, if they could have had leave to enter or remain, then they don't have the Zambrano right.
At one moment.
Can you just talk me through it again, because I'm maybe a bit slower than the Vice President. Can we go through the definition of person with a Zambrano right to reside on page 61, just make sure.
So
you have to show that you were resident for a continuous qualifying period. You haven't been told what that is, but
I can take you to the definition.
Your client has been here for long enough.
Well, it's actually a mechanism which is used to exclude not only periods of absence but periods of imprisonment and so on.
All right. So she gets over that with the derivative right to reside, and you get the derivative right to reside by satisfying, firstly, the criterion that you are not an exempt person.
Yes.
And secondly, the criterion that you are a Zambrano carer, to summarise 16.5.
Yes, or under BB, the child of a Zambrano carer.
Or
That's the paragraph 6, right?
And then, can you just talk me through the last bit, B?
Yes. So we can ignore the rest of BB.
Yes.
And then at the end of BB we get and then B, without leave to enter or remain in the UK unless this was granted under this appendix. So what the Secretary of State has done there on her own case is to repeat one element of what she says is a limit or an exclusion from the Zambrano right to reside, which is people who have leave to enter or remain. And that's why I say, strictly speaking, actually, it is otiose. It isn't required by the definition. It adds nothing to the definition, except for administrative convenience, that one can look at B and say, well, you had leave to remain.
To spell it out, it's otiose because of the effect of 16.5c.
Yes. On the Secretary of State's interpretation. On our interpretation, it's not otiose. Because on our interpretation, one can have both leave to enter or remain and a Zambrano right to reside.
What, a little b takes away the duplication?
So little b duplicates on the Secretary of State's case.
On your case.
On my case, yes. It's
little b takes away the duplication, which would otherwise be there.
Little b, well, I hesitate to agree because what is being judged here is not necessarily current leave to remain, but maybe historical leave to remain. And so what it does is it operates to exclude, would operate to exclude for policy reasons, a person who at any point in the 5 years before the 31st of December had limited leave to enter or remain even for one day.
That's stretching the language a little.
Well, it says without leave to enter or remain in the UK.
And that's granted under this appendix, yes. So that must be at the time of the application, surely.
Well, no, because the requirement is that they were if we look at the chapeau at the top, a person who has satisfied the Secretary of State. I think one can skip out possibly the next words.
Well, to get there, your key points are they are and for the relevant period have been.
Yes.
And if they had, even for part of the relevant period, been without leave to enter it.
That's enough.
Yes. Yeah. And that's certainly the Secretary of State's guidance. Yes, so there are people who have ceased to have a right to reside before the 31st of December, and the Secretary of State has refused them under paragraph B because they ceased to have leave to remain. Apologies. And the Secretary of State has refused them under B, but also there are cases that the Secretary of State refuses under little AA, because while they never had leave to enter or remain, she says they could have got it. So she implements what she says in her detailed grounds of defence.
Why is B otiose on that basis? If it means what you say it means, which is that somebody could have, in the past, historically during the period, had a lapse of time in terms of their entry requirements. Couldn't that live with the Secretary of State's interpretation? Because you could have, historically, you could have a break in your right, but at the time of the Zambrano application, you could have a ILR, or there could be exceptional circumstances under Appendix FM, for example.
But the requirements that must be satisfied under A and B are for the relevant period in which they rely. So that means that throughout that period, one must have had both a Zambrano right to reside and not had leave to enter or remain.
Remind me, what is the relevant period?
So the relevant period is not defined there, but my understanding is that the relevant period is the period for which the person asserts the continuous qualifying period. So this definition is...
I've been looking at the definition of continuous qualifying period. I can't understand.
Well, you have my sympathy.
Perhaps somebody else can.
Well,
Page 43.
Astonishing.
Where do you start looking?
the definition of continuous qualifying period, yes. So the definition of continuous qualifying period, as your Lordship says, at page 42, 43.
Is this how you would see it on a page? It's just mass of text and without any attempt to structure it or... well, it is a page, I appreciate it. Is this simply because it's been printed off the internet?
No, there are some versions. The internet version does not have indentation. Some of the PDF older versions have indentation. Sometimes counsel indents them by hand to help with comprehension.
I mean, this is...
Usually
okay, I mustn't just... but this is really shocking.
Well, the court has
It's
passed
so difficult.
Yes, I think it's very difficult because the drafting technique is to put all of the conditions in a definition.
Well, that's a different point. No, my point, I'm afraid, is a more basic point, simply about layout.
Oh, yes.
When you get very complicated provisions of this on the printed page, nobody likes them anyway, but if they're carefully laid out, you can see the structure.
Well, can I just try and help your Lordships with that? So the definition at the bottom of 42, a period of residence in the UK and islands. And there's then a long set stretch in the brackets.
Wait.
I'm so sorry. Bottom of 42. I'd invite your Lordships to underline a period of residence in the UK. And just ignore the rest of the chapeau, because it's about whether or not people were living in the Channel Islands and also had a Zambrano right to reside. It's not relevant. And then we have A. And there's an exception which here isn't relevant. The crucial words I'd invite your Lordships to underline are which began before the specified date.
What is the specified date?
The specified date is the 31st of December 2020, 11 p.m.
Yes, I see.
And invite your Lordship to underline and then B, during which none of the following occurred. And invite your Lordship just to underline B, Roman 1, absences from the UK. And then in the next line down, the words except for, and then the double-lettered subparagraphs, A, B, AA, etc., down to EE, are the exceptions to that Roman 1.
Where do they stop? They stop right in the middle of the page.
They stop. I'm just trying to. They stop 2/3 of the way down below FF, and I'd invite you all to.
No, they don't.
No, they don't. They stop at EE.
They stop the first EE.
No, because that EE continues into the sentence. That B Roman 3 is part of the same sentence.
Yes, I know that is, but then the next line there's a little Roman 2.
Oh Lord, yes, I see.
You're right. You're right. I'm so sorry. I was skipping down to the next C. You're quite right. 2 is for certain sentences of imprisonment, and then Roman 3 is for deportation orders.
Wait. So 3 starts almost only 2 lines further on. And how do we know that's about deportation orders?
Well, I would invite you to underline any of the following in respect to the person, and then Roman AA is any decision or order to exclude or remove under Regulation 23, which is effectively a deportation decision.
As is double D.
As is double B, double C, double D, double E, double F. And then C, which is the first order.
So what do you mean, the first? I see the first order.
In terms of A, B, and C being the primary divisions of the definition. And C, which continues at the date of application. And then there are 2 exceptions to that,
If you've accumulated 5 years by the deadline of the 31st of December, then you're okay, basically.
yes, exactly, madam. And I think what happens afterwards is, for present purposes,
But
irrelevant.
then you've got, it probably is, but
Yes, no, I'm happy to continue.
I mean, this is just my point about layout. You've got little Roman 1, you've got little Roman 2 AA, you've then got a BB, and then you've got an AAA.
Yes, I mean, I
And
think
when you get to the BB,
there's no other D, so the C is the last of the first orders. And in terms of second orders, you have a Roman 1, a Roman 2, and over the page are Romans, right at the halfway down the page are Romans 3, 4 and 5.
so is C the last first order head?
Yes.
So everything else is under C. And,
Yes.
and the break in the middle of page 44 in our bundle is concerned is that just a type, is that meant to flow straight on?
It
there's no
then
punctuation.
explains a series of reference definitions of the terminology within that definition. So your lordships will see in addition relevant reference in subparagraph
So why doesn't it
C.
start with a capital letter? I'm sorry, this may sound very pernickety, but it actually makes it completely incomprehensible if it's not punctuated.
I appreciate that, my lord.
It's like an 18th century deed where they sort of make a point not to have any punctuation.
Well, it may be that, I mean, certainly with hindsight, it would have been better to have provided your
Well,
lordships
of course, everyone knows. Well, there we are.
See that now.
Mr. Blundell, you rightly anticipated that at some point I would blow my top about this. But I hope the message has got back to those behind you that this is a shocking way to legislate. But how? It's not just a question of how can the ordinary citizen, how can any lawyer understand this without extraordinary, well, not just the concepts are difficult, just the way it's laid out is so absurd.
Well, my lord, I absolutely have the point. There are, as I've indicated earlier, people in court today from the Home Office. Mr. Lamont is here. I'm sure what your lordship has said will have been heard. I cannot possibly say anything in defence.
No. Well, anyway, in a way, it's a red herring, but it's not a red herring.
No, I take
it raises an important point about the rule of law, really.
No.
It would still be a very difficult thing if it was carefully laid out, but at least you'd see how all the parts fitted together.
I know I've been in this court before when we talk about transitional provisions in immigration, and it's been the same issue.
Okay, enough said. I'm glad there are people in court who
the message will have been heard, my lord.
Right. So we're coming back just to trying to understand. So that is what a continuous qualifying period is.
Yes. And the key elements for the purposes of your lordship's consideration are, first of all, it is a period of residence.
No, but sorry, we got onto that by asking what the relevant period have been.
Yes.
How do we know the relevant period is a continuous qualifying period?
Well, my lord, I think if we go back to the relevant period is not one of the defined terms, and so in my submission, it's a question of inference that the relevant period is, and perhaps blessedly, not an attempt to exhaustively enumerate precisely what it is, but one understands it in the context as the period which, in respect of which the conditions need to be satisfied in order for there to be a person with a Zambrano right to reside. So, for example, a person who claims...
So that will be the continuous qualifying period, won't it?
Yes. So the person claims to have been a Zambrano right to reside for 5 years before, but continuing down to the 31st of December, then it will be the 5 years down to that date. If they didn't do 5 years, it'll be, actually, it'll only need to be the last date of that period.
Is that why it matters in practical terms to your client? In other words, she needs to have the Zambrano right for 5 years in order to qualify under the provisions that fit at the 31st of December?
She had it for 5 years.
Yes.
And then she got leave to remain, and she had that leave to remain on the 31st of December. So what she needs to have
Right,
is
so she's
5 years.
already historically had the 5 years, and then she gets another right to remain thereafter.
But that doesn't
At least an overlapping one. Secretary of State says
Continuing.
a destructive
Well, an additional
one.
yeah.
Well, the Secretary of State says that destroys, removes
Yes.
the
But
Zambrano.
is that why would it do that? Because it says by the, not at the specified date, but by the specified date. So suppose on a particular day you haven't got a Zambrano right, but by that date you had, or do you think it's because it's have been rather than had been?
But it's also under 43.
I think the answer to my question is have been rather than had been.
But it's also, my lord, in the definition of continuing qualifying periods, continuous.
It's either
Yes,
it's either
continuous,
a
not
period ending on 31st December 2020 or an accrued right of 5 years continuous. Is that right?
It has to be our position, that I think we would be happy to be told otherwise, but our position is that there must be a Zambrano right to reside on the 31st of December
Yes.
2000.
So it doesn't matter if you have the Zambrano right to reside and it's been superseded by another right. You've got to actually have the Zambrano right on the 31st of December.
Yes, the only
Seems a bit
exception would be if it was superseded by one of the other qualifying rights.
Yes, I understand that. ILR, for example.
Well, no, under the appendix. So, for example, if one went from a Zambrano carer to, as the court discussed this morning, to a Chen, or a sharer carer.
That really just means one other thing I wanted to understand, which I think I've understood. When I was trying to make sense of this before, I was puzzled why there was a distinction between a person with a derivative right to reside and a person with a Zambrano right to reside, because the Zambrano right to reside is a derivative right to reside.
Yes.
It's a subset, but really what this should mean is a person with a derivative right to reside other than a Zambrano right.
Exactly. But on this occasion, they chose the slightly abbreviated version of the definition. And we see that from that definition that your lordship will have at page 60, that definition, person with a derivative right to reside, has 3 requirements, A, B, and C. And C, excluding a person satisfying the criteria in paragraph 5 of Regulation 16. So, on the face of it, and this hasn't been the subject of argument, but on the face of it, it would appear that in this scheme, the Zambrano right edges out the other derivative rights to become the right. And your lordships will also notice that the definition of person with a derivative right to reside does not include the paragraph B exclusion of person, the paragraph B requirement that the person did not have leave to enter or remain.
Is there any, well, is maybe addressed more for Mr. Blundell than you. Isn't there any obvious rationale for that distinction, is there? Or is there?
Well, the a rationale is the rationale for paragraph B, which is that the Secretary of State understood paragraph B to be doing no more than reflecting the fact that a person with leave to enter or remain could not have the Zambrano right to reside anyway. But clearly the Secretary of State has not reached the same view. Well, the inference would be the Secretary of State has not reached the same view about the other derivative rights to reside. Or at least as a matter of policy, didn't think it necessary to include a out of abundant caution provision on it.
Well, it's more likely to be the latter than the former, isn't it?
I don't know. But my lords, that is why I say this arises. And what we say in short is the position, paragraph 18 of our skeleton, is that the Zambrano right or obligation of the member state does not cease to exist when it's met and revive when it's neglected. And that is why there can be simultaneously a right to reside under European Union law and a domestic residence permit. And what I want to do to try and explain to your lordships why the Secretary of State was quite right to think that that was a legitimate implementation of the Zambrano jurisprudence, because there does not appear to be any dispute that that is what the Secretary of State thought the Zambrano jurisprudence meant. It's in her guidance.
I'll say that more slowly.
Well,
Or you're about to make it good.
It doesn't
Well,
cease to exist when it's met, you say?
it doesn't cease to exist when it's met. Yes.
What does that mean?
Well, what it means is that the Zambrano jurisprudence imposes an obligation on member states, and that obligation does not disappear because the member state grants the person a formal recognition that they have the rights that Zambrano requires them to have.
Right, so the obligation doesn't disappear when you grant a Zambrano right.
Well,
But my lord,
but is this?
I will come on to develop.
No, I know. Well, can we just, while we've got it,
Okay,
because I want to
yes.
try and understand it, and I may forget it later. It's not so much about granting a Zambrano right. The way Zambrano works, it exists whether you don't need to grant it. It's there whether you grant it or not.
In domestic law.
Sorry?
In domestic law. In UK domestic law. Yes. But not as a matter of EU law.
Well, would a better word be recognised?
Yes.
It would be in domestic law, but it wouldn't necessarily be in all of the legal systems of all of the member states.
But the Zambrano right in the jurisprudence of Luxembourg is simply a right which everyone has if they are a carer of an EU citizen to reside and to work.
Well, sorry. It's actually threefold, my lord, as we'll see
All
from
right,
Sammy. It's the right to reside,
Yes.
it's the right to work, and it's the right to social assistance if you need it. And we'll see that from Sane. So it's in fact a threefold right. And
Okay,
we'll also,
we'll come back to the
We will.
social assistance, but I'm just trying to get conceptually what
Yes.
you say the position is. That the EU right, whether recognised or not, simply arises because of those circumstances. It is, in a sense, from the EU point of view, a matter of indifference whether, or if so, how, those rights are recognised by implementing legislation in member states.
indeed.
If they are, all that's happened is the Zambrano right has been, if you like, recognised or satisfied or given effect to by a piece of domestic litigation. But that doesn't extinguish the right.
Yes.
It embodies the right.
Yes. It respects the right. And in fact, if we...
Well, probably in correct EU jurisprudence, it's a bit more than that because this is a directive. It's not as such directly effective. It may be accidentally directly effective because it's against a public authority. But nevertheless, the concept behind a directive is that you are telling the member state to implement it.
Well, my lord, it's not a directive. I think that's quite important.
Of course.
It's a
no, of course you're right. You're
it's
right.
a provision of the treaty.
It's a helpful mistake on my part because
Yes,
it enables you to make your point.
And the treaty does not require it to be transposed.
Yeah.
So the article in the treaty that requires directives to be transposed does not apply to the Article 20 right. So member states have the widest
it is effectively a right which is parasitic on the Article 20 right and is therefore directly effective as such. So it doesn't require to be transposed. Yes.
Well, whether
Once
it's
the right
directly...
arises, sorry to interrupt you.
Please.
Once the right arises, it is dependent on a particular state of affairs. If that state of affairs continues, that right subsists. Therefore, you say, if as a matter of domestic legislation, the carer's immigration position is reflected or recognised in a different way, that doesn't affect the Zambrano right, which still continues.
Yes. Well, when your ladyship says a different way, the court's jurisprudence doesn't speak of any particular way.
No, but,
And the court...
but as long as the Zambrano carer has got a means of implementing the right which is there, and it doesn't really much matter what label you attach to it. It can be done under one set of legislation or another, but they have been given leave.
Well, if I could just take your lordships back to your lordships and my lady back to page 179 of the authorities bundle, just to see what the ruling in Zambrano, because while we speak of it as a right, that is actually a national law implementation of it. Just want to be clear about what EU law requires.
Sorry, where are we?
So page 179 of the authorities bundle, just to the holding in Zambrano.
Yeah.
So what the United Kingdom was required to do, what the United Kingdom was precluded from doing, was from refusing a third country national
A right of residence.
a right of residence, from refusing to grant a work permit. Now, in fact, as your lordship has observed, the Vice President has observed, we don't have work permits here anymore.
No, that's an EU language.
Exactly.
But it is defined as a right in paragraph 45.
Well,
It's plain as a pikestaff.
it's defined as what the European Union obligation is that member states are precluded from refusing.
Sorry, you're wrong. Look at paragraph 45 with
Yes,
the greatest respect.
Of course.
Paragraph 45 says that the answer is that Article 20 is to be interpreted as meaning that it precludes them from refusing a right of residence. That must mean that they have a right of residence. Or are we dealing with angels on a pinhead here?
Well, what the court is doing is using the language of the international relations between the EU and its member states and telling them what their international law obligation is, what they are precluded from doing. And I entirely accept that in practice that means that a person has a right to a right. But the nature of that right is a matter for the member state. All that the European Union law requires is that they be precluded from
Denying it.
from denying a right of residence, and the quality of the right of residence that they must grant is a matter for domestic law implementation. And this is a case about the quality or the characteristics or the formalities of the United Kingdom's choices about implementing the rule in Zambrano. Now, I just wanted to then talk briefly, or address your lordships briefly on why this case hasn't, why this point hasn't arisen before, and therefore, in my submission...
So, can I just talk about a gap? Is really a domestic law concept. It's not an EU law concept. The EU law concept is you always have the right.
Yes. Where EU law is engaged.
Yes. In practice, because you are always proceeding in a national jurisdiction.
Now, I need to deal with it. I will.
Oh well, all right. Don't leave it. Keep that thought in your head for a moment.
Of course.
A gap only arises. You only need to, quote, invoke the Zambrano jurisdiction where you don't get it by any other route. But that's a domestic law problem.
Yes.
Because the domestic system has, in certain cases, for example, between the date of the Zambrano decision and December 2012, hadn't got anything in its rules which recognised the Zambrano right. But you say it's putting the cart before the horse to put the domestic law situation, when you're looking at what the EU Zambrano right is, to say it only arises where there is no domestic right. It's a right that always exists. It's a problem for the domestic court, how perfectly or imperfectly it vindicates that right.
Yes. Well, in the
domestic system.
Exactly.
Well,
and here it was
only once it's already arisen. It can't always exist conceptually. unless there is a gap to be filled, because that's the whole ethos of the right. Unless there is this situation which arises where there would be otherwise a compulsion of somebody to leave the EU if the carer wasn't granted rights, then there is no Zambrano right.
Well, what I will show, what I hope to show the court is that the right arises save where EU law is not engaged, and that's the point about EDA. So where it is absolutely theoretical in the language of, where it is theoretical in the, as in the language of EDA, EU law is not engaged, and EU law doesn't touch what the domestic authorities need to do. But, and my submission is that's why the Secretary of State excluded indefinite leave to remain. Because in those 18 months that the Secretary of State was carefully considering this, one of the things that she would have been doing was asking, what do I need to do to make sure that I don't get into trouble with the Commission, that I fully implemented the Zambrano right? And as we shall see on my learned friend's construction, as he almost admitted, or was almost forced to admit, if he's right, well, people might not have the right to work, which would defeat the whole point of Mr. and Mrs. Zambrano, Maurice Zambrano's actual case. Now, on our interpretation, what the Secretary of State has done is says, well, I can identify an entirely theoretical case. That's indefinite leave to remain. But otherwise, I don't know that limited leave to remain would comply with the Zambrano right. I mean, suppose it didn't have a right to work. Would that comply with the Zambrano right? Suppose it excluded a person from claiming any sort of social assistance. Would that comply? Or what I should do when I'm implementing, I say it's not gold plating, it's just implementing. When I'm implementing what the treaty has told me to do, is I'm going to recognise that the right arises where the child would be compelled to leave. If the parent had to leave, I'm going to create a very fact-sensitive question about the compulsion directed at the child, but I'm going to take away from the decision makers in the Home Office the question of whether or not lack of right of work, lack of access to benefits, need for a right to reside would compel this parent to leave. That's not how I'm going to implement it in national law. Now, my lords, my lady, this case is an important one. There are currently some 5,750 undecided Zambrano cases and something like 2,200 refused cases, which certainly on the evidence before the court below are likely to comprise a significant number of lookalikes, as it were, with Miss Akinsanya's case. But there are some other reasons that I want to come on to as to why your lordship's ruling on issue 1 will be important. But firstly, might I just briefly explain why the issue arises now? Until 2019, the rights consequent on recognition of a Regulation 16.5 right to reside were the least favourable in the hierarchy of rights in domestic law. While they did lead to a 5-year residence permit with the right to work, they did not lead to permanent residence or indefinite leave to remain, and they did not lead to entitlement to mainstream social security benefits.
Hang on one second. So 2 things, no route to settlement and no entitlement to mainstream social security benefits.
That's right. Now, other routes, and in particular when it was introduced, which was after Zambrano, Appendix FM, did provide the possibility of indefinite leave to remain after 10 years and the payment of a very substantial fee, which I think is somewhere in the order of £2,000 or £3,000. And the Appendix FM also provided the possibility of obtaining mainstream social security benefits, which is what Miss Akinsanya achieved when the Secretary of State agreed to grant her it without a prohibition on recourse to public funds, the prohibition being the default. So up until 2019, in our legal system, nobody who had another kind of leave to remain would have been arguing for Zambrano leave, unless it was, for example, as a student or as a visitor, or in my Lord Vice President's example, someone with limited leave to remain with a prohibition on working. But we know from the Secretary of State's guidance, if I could just show this to your Lordships, page 691 of the bundle. And this is the operational guidance that was issued with the amending regulations in 2012. So sorry, it's tab 21. And your Lordships will see that the language so what this is it's from the European Operational Policy Team, subject to derivative rights of residents, and I'm taking your Lordships this to show the factual scenario as to why we are where we are today. But your Lordships will see in paragraph 3 that the language of the guidance very much reflects the Secretary of State's explanatory memorandum. Zambrano judgment established that member states cannot refuse a person the right to reside and work in the host member state where, and then the second bullet, refusal of a right of residence to that primary carer would deprive the Union citizen of the substance of their European citizenship rights by forcing them to leave the EEA. And then we see in practice this means that the primary carer of a British citizen who is residing in the UK has a right to reside under EU law if their removal from the UK So we see would require the British citizen to leave the EEA. We see in these two places both the Secretary of State's understanding of the jurisprudence and then the language of the regulation. And we see over the page under the heading, the middle, Zambrano rights of residents exempt persons, we see the explicit recognition in paragraph 10 where someone has limited leave and so is not listed as one of the exempt categories above and can demonstrate that they meet all other requirements of regulation 15A, then they can acquire a derivative right of residence. And that was the Secretary of State's position until 2019. So if there is an obvious mistake, it was a carefully considered an obvious mistake, and it was a very long-lasting obvious mistake. And that's why this case hasn't arisen before, because the Secretary of State didn't hold it against people that they had limited leave to remain when granting them Zambrano residence permits. Turning back then to the way that the scheme works now in practice, of course, the European Economic Area regulations no longer apply to new cases. They have stopped, they were repealed with effect from the 31st of December 2020. And so any person who comes to the UK after that date or who has a British citizen child who's born after that date won't be no question of the EEA regulations applying. But the regulations matter, as we've already discussed, because of they form the conditions for the application of Appendix EU. Who then may qualify under Appendix EU on the Secretary of State's reading of the Zambrano right? It is a person who does not qualify for any other leave to remain. Those people are people with criminal convictions, where the criminal conviction is sufficiently serious as to outweigh their Article 8 rights to remain, but not so serious as to meet the European Union public policy.
Sorry, I got lost. Why are we talking about these criminal people?
Well, because what I want to show to your Lordship is why it matters, and I'm going to come on to why it matters for the future in a moment. But what I wanted to explain to your Lordship, because you might have been wondering, who can qualify for a Zambrano right of residence under the Appendix EU? If
it means what the Secretary of State means.
Which is anyone who could qualify for Article 8 leave. Because you might...
I got completely lost. What's Article 8 got to do with it?
So the basis upon which the respondent has leave to remain is Appendix FM. And Appendix FM is essentially the Secretary of State's domestic implementation of Article 8 rights for family members.
Yeah.
So in order to get into mainstream benefits, she needed to persuade the Secretary of State that her expulsion would violate Article 8. She qualified under his scheme.
Yes.
And in the Secretary of State scheme, that's now reasonably readily done for people who don't have criminal convictions, if they are the sole carer of a British citizen. So one might then think that all of the Zambrano carers would equally qualify under Appendix FM. There isn't a class who fall under the definition.
I hadn't really thought about this.
Well, unless
So
unless they're not directly related to the child. If they were an aunt or an uncle, or a godparent or a family member, and the child was orphaned, for example,
it's possible.
they wouldn't qualify under Appendix FM, but they might under Zambrano.
But they might qualify under Article 8 as well.
They might buy under Article 8.
Article 8 rationale.
Yes, outside the rules.
But the obvious candidate who doesn't qualify is someone whose conduct outweighs the Article 8 rights concern, which, as your lordships will have seen from the cases that come before this court, is a demanding test for a person who's been convicted to show that they have Article 8 rights. But under EU law, if I could just take your lordships to
it's got to be really serious.
Regulation.
Especially if they've been here for 10 years.
it has to be really serious, and it is applied to the Zambrano cases. So if I could just ask your lordship to turn up Regulation 16, which begins at page 25 of the bundle, carries on to page 27.
Hang on, I'm just making a note. Sorry, where are we going?
So to Regulation 16, and just to the last paragraph of Regulation 16, paragraph 12, which is at page 27 of the bundle of tab 3. To an exclusion from the rights to reside under Regulation 16, where the immigration officer has made a decision under, and there are various paragraphs listed, but the crucial one is 23.6b, which is a decision to remove on public policy grounds. So that is the, as it were, the criminal exclusion from Zambrano. Now, a person whose seriousness doesn't attain that level, but whose seriousness attains the excluded from Article 8 level, these are the people who are left qualifying under the Secretary of State's Appendix EU scheme. And that matters for the future application of the scheme, because on the Secretary of State's interpretation, people who on our interpretation would have Zambrano rights lose their protection from deportation under their EU law protection from deportation for good from the 31st of December, unless they had already committed offences that were serious enough to exclude them from
Is
Article
all this in your Statutory argument, Mr. Cross?
my lord, it's not in Article.
I'm finding it very difficult to follow.
I'm
You're
sorry.
very familiar with it.
I was simply trying to explain the context, but
Well, I don't want to stop you, and
No.
if my lord and my lady are more optimistic than I am, that we will be able to.
I'm sorry. I meant maybe that I could better do it by way of a note.
I mean, you do, speaking for myself, you and Mr. Blundell both know this material much better than I do, and you're assuming quite a lot of knowledge.
I appreciate that.
Saying here.
Well, my lord,
And it's not just my lord.
no, I apologise for not laying the groundwork.
I think if this is an important point, as opposed to just some interesting general background, I think we need a note about it, with it all set out. I don't at the moment understand the structure of your submission enough to know whether we're still on at nearly 3 o'clock on introductory material or on the real points.
I thought it was a pejorative point, which was the nub of which is if the Secretary of State's right, then all the bad guys stay here and all the good guys go away. Is that being a little terse?
My lady summarises half the point absolutely accurately.
Right.
But
But
the
it's
other
a
half,
slight, it's a slight parody of the point, isn't it? If the Secretary of State is right, you say only the bad guys need a Zambrano right, because everybody else with any sort of leave to remain is catered for.
yes. But also, and this is the second half of the point, if you didn't have the right on the 31st of December, you lose the protection of EU law for good. And so that the judgment that your lordships make will not only affect whether people qualify for leave to remain under the Appendix EU or may qualify, but will affect whether or not they retain rights under other parts
Under
of
the
the
EUSS.
actually under other regulations that protect people who had EU law rights from deportation other than under EU law conditions. But I will return to the structure, to the submissions made in the skeleton model. So I think from the discussion this morning, your lordships have the point that on a straightforward reading of the regulation implements the Zambrano case law in a way that allows for recognition or existence of a Regulation 16.5 right to reside at the same time as the existence of leave to enter or remain. And therefore, in my submission, the Secretary of State's challenge is to show that that is incompatible with the Zambrano jurisprudence. And in my submission, it is compatible with the Zambrano jurisprudence. The Secretary of State hasn't identified any change in the jurisprudence that's led her to change her mind. We saw a brief explanation, or a brief stepping back from the Court of Appeals judgment in Patel, but I can deal with that if needs be. But what I want to do is to take your lordships to Sane, that in my submission helpfully addresses, my own friend didn't go to tab 13, helpfully addresses the position, as it were, directly under Article 20, and this is a judgment of this court, with two recent judgments of Lady Justice Arden, as she then was, Lord Justice Elias and Lord Justice Burnett, with Lord Justice Burnett agreeing with both the other judgments. And Sane concerns the position before the 2012 regulations were made, and we can see that from the facts of Miss Sane's case. She was one of the claimants, at page 414, at D.
Sorry, which page at D?
414. You see that Miss Sane appealed a decision on the 13th of July 2011 to refuse her application for income support, and it was then decided by the tribunal on the 28th of November. I think there must be an error there. I think that must have been the Social and Entitlement Chamber, but it doesn't matter. And that's why when we look at the judgment, we don't see the court referring to Regulation 15A, which was already enforced by the time the court was looking at it, but we see the court referring directly to the treaty. And the reason for that is that this case concerned entitlement to social security benefits, and the social security benefit regulations refer directly to the treaty. We see that at 426. At the bottom of the page, paragraph 13, it's not necessary to look at each set of regulations, and those regulations are listed above paragraph 11. the effect of the DWP regulations is to insert into the list of rights of residents, and then if one omits the words in brackets, which disqualify a person from a range of income-related benefits, including housing benefit and job seekers allowance, the following right of residence. And we then see a description of that right, which corresponds to the language of the holding in Zambrano. So the Social Security regulations didn't.
So these regs had been amended, or perhaps drafted for the first time, I can't remember which regs they are, post-Zambrano, and to reflect Zambrano.
Yes, but not by reference to the immigration regulations.
No, I understand.
Yes.
By reference
Oh,
to
yeah,
the
absolutely. Sorry, yes, they were drafted to give effect to Zambrano, and they were drafted to exclude people from entitlement to these social security benefits if essentially their only right to reside was a Zambrano right to reside.
Yes, we can see there are amendment regs from 2012. Yeah, okay.
Now, the Secretary of State's case in Sane is summarised at the top of page 431, paragraph 37. And I should say that there were, the first point concerned that what Lady Judges are the last state and the first state, the last state being when there was compulsion to leave, and the first state to leave being when it was alleged that the Zambrano right to reside had come into existence. And what I rely on in particular is the Secretary of State's submissions about entitlement to social assistance. And we see Roman 2, it is national law and not EU law which controls the amount of social assistance to which Zambrano carers are entitled. The Member State's obligation does not extend beyond refraining from taking prohibited national measures against the carer. If the Member State is required by EU law to pay any social assistance, and the Court goes on to decide that it was, it is obliged only to pay an amount that is adequate to prevent departure of the EU citizen child from the EU, and the Court accepted that.
Sorry, which bit are you reading?
Paragraph 37, I'm so sorry, at the top of page 431.
Aye.
Now,
So social assistance, that means effectively you're not entitled to mainstream benefits, but I'm not enough of a benefits lawyer to know which they are, but those sorts of discretionary benefits for people in real distress will cover the Zambrano.
what the court goes on to hold is that there was no breach of the Zambrano principle by denying people with who had the benefit of that principle the right to access job seekers allowance and housing benefit because they were to be provided under the Children Act.
Yes, I see.
Even though that was less favourable.
Yeah.
So much of the case concerns a discrimination argument. But what's significant in my submission is the Secretary of State's submission in paragraph 38 towards the bottom. At D, the Zambrano right is on his submission negative rather than positive in nature. It is an immunity from national measures which destroy the substance of the citizenship right of the EU citizen child. The obligation on the Member State is to produce a result to refrain from prohibited national measures. EU law does not care what sort of right is given to the carer. And I agree with that. What I don't agree with, and the court didn't agree with, is the next sentence: it is sufficient for the Home Secretary to agree not to remove the individual. I just want to look at what the court said about those submissions. So, at paragraph 58, page 434, the court deals with submissions made about direction and a reference to Article 8 Now, in Direcci, the Court of Justice had said that member states would have to consider Article 7 of the Charter in a case that fell within the scope of EU law, but only Article 8 of the European Convention in cases that fell outside the scope of EU law. And Lady Justice Arden gives her view on that at 59. The significance of the reference to Article 8 is surely that the CJU contemplated that there will be cases which are outside the scope of EU law, so that Article 8 of the Convention would apply, and not Article 7 of the EU Charter. Therefore, if the applicant does not have the attributes of a Zambrano carer, the national court will be thrown back on whatever right to reside may exist under national law. That would be the case, for example, if the question of the EU citizen child having to leave the Union is academic. See EIDA, and I will take your lordships to EIDA because it's the closest that the court comes to answering the question that your lordships have to. That indeed was the situation in Direcci, and it seems reasonable to conclude that was the situation which the CJEU was addressing in paragraph 72. Now in Direcci, there was a similar case to Chavez-Vilches, husband and wife, wife allowed to stay, husband being deported. The question of whether deportation of husband breached the children's rights. Now, that's how Lady Justice Arden dealt with the case of Direcci, those other cases she mentions there, or EIDA. She then gives, when she turns to her own reasons, over the page at 436, paragraph 68, matters of entry and stay for non-EU citizens are matters outside the exclusive competence of the EU, but the CJU has laid down the principle that decisions which member states take on these matters must not be such as to make the rights of EU citizenship ineffective. Over the page at 71, after she cited Baumbast and Chen, which concern other kinds of derivative rights, as your lordships have seen, she says, in my judgment, these cases throw considerable light on Zambrano and demonstrate its place in EU law. While Zambrano is intended to apply only exceptionally, it is not an exceptional or unprincipled piece of jurisprudence. It forms part of the wider principle, which I have called the effective citizenship principle. And then applying that principle, she says that answers the issues. And in particular, she recognises that paragraph 73, that there must be a right to work, and then paragraph 74, given that the Zambrano carer's right is to reside so as to support the status of the EU citizen child, it makes no sense that the right should arise only from the last date. The fact that presence in the UK without a right to reside would also put the Zambrano carer in breach of the criminal law, even if it were to be an abuse of a prosecution to be brought, confirms this conclusion. But in my submission, what's significant there is that Lady Justice Arden is holding that the requirement for the right to reside doesn't arise only when removal is threatened. And in my submission, that's dealt with in more detail in the judgment of Lord Justice Elias, at page 453. And paragraph 166, so he first of all says he's in broad agreement with the judgment of Lady Justice Arden. And then summarises the Secretary of State submissions. Secretary of State submits that...
Which paragraph are we on?
166. Your Lordships will just read 166. And would your Lordships read on to the end of 168? paragraph 70, you see Lord Justice Elias.
Paragraph 170.
170, yes. It's a point that I made to my Lord the Vice President earlier on. The right to reside conferred by EU law takes effect automatically in domestic law. And
That means, I'm just spelling that out, because it is a treaty right.
Because Section 7 of the 1988 Act gives it effect in that way.
Sorry, what is it? Section 7?
Section 7 of the Immigration Act 1988.
What does that say?
That says that a person who has an enforceable community right to remain does not require leave to enter or remain.
Yes, I see.
And it is that right which gives which lifts the prohibition that would otherwise exist on working. And we'll get a copy of this to your lordships. But Section 15 of the Immigration and Asylum and Nationality Act 2006 prohibits an employer from employing a person who requires leave to enter or remain and either does not have it or has it but subject to a prohibition on working. Now, a person with the Zambrano right to reside does not require leave to enter or remain and is therefore not caught by Section 15, which is why, as a matter of law, they can be legally employed. As a matter of practice, they will require a residence permit to prove that they have that right. But that is the way that UK law implements the Zambrano principle. It's not the way that EU law, it's not the only way that EU law requires the principle to be implemented. As Mr. Coppell told the court in Sane, EU law does not care what sort of right is given to the carer. Subject, obviously, to the fact that it is sufficient to meet the requirements of the Zambrano principle. But the argument that a right that goes an iota or a millimetre or an inch or a foot beyond what another state might think was the bare minimum does not mean that there's gold plating. It just means it's being implemented in that particular way by that particular state, which, after all, under the principle of subsidiarity, has a broad freedom as to how to implement the treaty. And we can see that in the three different rights. And in the incoherence of my learned friends' construction for those three rights of residence, work and benefits. And the last one is the benefits. We see that that's dealt with in Sane, page 171. Paragraph 171, I'm so sorry, the bottom of page 454. I agree with Lady Justice Arden that the logic of the Zambrano right is that where the carer does not have the resources to remain in the country, so will in practice, absent state support, be compelled to leave with the child for economic reasons, there will be an obligation on the state to take steps to ensure that they are able to remain. EU law focuses on the substance of the right and not merely the form, and will require the state to take steps to ensure that the essence of the right is respected. That does not, however, require the state to guarantee any particular quality of life. But again, the precise extent of any social assistance that the state gives is a matter for the state. And so what my learned friend has focused on is a series of cases in the courts in which the courts have had to grapple with the individual facts and ask whether this particular factual situation would violate EU law. But when a state implements EU law, it isn't forced to give its officers only the limited power to decide on a particular factual case-by-case basis whether or not their rights will be violated. The state is entitled, when implementing EU law, to say, if you haven't got indefinite leave to remain, you may be forced to leave the UK.
This is an important submission, so I think it would help if you slowed down just a bit.
My lady.
So the state is entitled to implement the right in whichever way it chooses. Yes?
Yes.
It may choose not to say it's fact specific in every single case.
It may choose to do so by regulations which do not give the individual officer the power to, or the duty rather, to examine every fact.
Yes, so it may choose to produce something which is more broad brush in recognition of the fact that there may be circumstances, not all, but some, in which somebody with a limited right to remain would fall foul of Zambrano on the individual facts of the case.
On the particular narrow point, yes, but before one gets to that broader point, that when the state is asked, for example, what kind of work permit must you grant? What level of social assistance must you grant? EU law implementation allows the state to choose
Yes.
within the parameters of the Zambrano principle. So my learned friend submission is, by looking at individual cases where the court was asked to decide, would there be a breach? He says, we can see from those cases that actually there aren't broad parameters. It's a straight line. You either qualify or you don't. There's no room for real disagreement about this. But that's to mistake the process that the court was going through in those cases. But that's to assume that the process the court went through is the only way in which member states can implement the principle. And as a matter of EU law, member states can implement a treaty through regulation. And the regulation can set clear, bright lines for Secretary of State's busy staff.
Indeed, is there an obligation to implement a treaty right in that sense?
My Lord, it's not something that has been explored in these proceedings. I think as a general proposition, there is certainly no explicit duty.
There's an expectation.
There is a legal duty to respect the right. But
Yes, but if,
there's no duty
if as
to
we do by
transpose it.
having the Section 2 of the European Communities Act, it's really all, Section 2.1, that's really all you need.
I think that's what the draft person of the 72 Act thought, yes, and I think they're probably right. But other states may do it differently. But while the treaty tells member states you must transpose a directive.
But anyway, in this case, we did, for perfectly sensible reasons, the Secretary of State, whether or not she was obliged to, thought it was sensible when she thought about it sufficiently to create a structure that respected the Zambrano rights.
Yes. And the Secretary of State's case now is that she gold-plated. She went beyond. She went outside the scope of EU law. In effect, she went beyond the parameters of the Zambrano right. Now, I just want to, before turning to the case law, I just want to try and make good my submission that this produces that my learned friend's case produces this incoherent outcome. It concerns the point that my Lord the Vice President raised at the outset about work, permission to work. On my learned friend's case, if I have permission, if I'm in here as a visitor with a prohibition on working, I don't have a Zambrano right to reside. That's my, as I understand it, that's my learned friend's case.
To say it again?
If I have leave to remain here as a visitor with a prohibition on working, I don't meet the requirements of Regulation 16.5c because I'm not faced with expulsion from the UK.
On his case, you don't even get to the regulation. As a matter of EU law, the Zambrano right doesn't arise because there's no gap. There's no possibility of a risk of being compelled to leave at that point.
Yes, and Zambrano tells us that's wrong, because if I'm prohibited from working, that's a breach of the Zambrano right. So in the domestic scheme, how do I get a right to work if I've got leave to enter or leave to remain that has stamped on it a prohibition? Well, I have to escape from the leave to enter regime. I have to not need leave to enter or remain. The only way I can do that is by having a Zambrano right to reside. That's the only mechanism in domestic law. So on the Secretary of State's own case, people can have both a Zambrano right to reside both limited leave to remain on the face of it, and in order to have the right to work, a Zambrano right to reside.
Well, is that right? A Zambrano right to work?
But my lord, the only way to get the Zambrano right to work in our domestic scheme, the only way for an employer to employ me lawfully is if I do not require leave to enter or remain under Section 15. In order to not require it, I have to be under Section 7 of the Immigration Act. I have to have a right to reside there. What's the basis of my right to reside?
Instead of having a visitor's permit, you apply for the Zambrano right instead.
Yes, but what happens to my
So
right?
don't go together.
But what happens to my right to work before I'm granted it?
Well,
You
you
don't
have
have one.
Well, but under
have
Zambrano,
it straight away. It may be difficult to enforce.
I have it straight away. On what basis do I assert to my employer? On what basis does my employer defend himself against the charge of illegal employment? He says, well, this person didn't require leave to enter or remain in the UK. They had a Zambrano right to reside. That would have been that ended up being Mr. Zambrano's answer back in the Belgian court when they tried to keep withholding his unemployment benefit. He said, well, actually, I had the right to reside back then. As my learned friend showed you this morning, Mr. Zambrano's case was not about current expulsion. It was about historical meeting of Belgian unemployment benefit conditions. So Mr. Zambrano was found by the Court of Justice to have had the right to work, even though domestic law said he didn't have it. And that's how the UK would implement the Zambrano right. So in order for the UK system to respect the Zambrano rights, my learned friend ought to accept that a person whose leave to remain prohibits working can simultaneously have the Zambrano right to reside. Now, he might be able to say, well, that's fine, that's because otherwise there would be a gap in the protection. The gap isn't only about the right to reside, it's also about the right to work and the right to claim benefits. It's three kinds of gap. At that point, EU law has to step in. But all of that, in my submission, is grist to my mill and Mr. Koppel's mill. EU law doesn't care how.
What's Mr. Coppell got to do with this?
Mr. Koppel, counsel in Sane. EU law doesn't care how you implement it. What you need to do is implement it within the parameters of the right. Might I then turn to the parameters of the right? And I think there are two cases against me. They are NA, also called A, and IIDA, or AIDA. I'm sorry, my Japanese is poor. Turning to NA first, or A, which is, I can actually just turn to the last page, which is at 292, just before divider 10. It's at the end of divider 9. And the holding in that case, in paragraph 3 of the holdings,
This is the dispositive, yeah.
Does not confer a right of, Article 20 does not confer a right of residence. And then down at C, where they qualify for a right of residence in that member state under a provision of secondary EU law. That was the answer to a case which the court had observed, 289, paragraph 69, raised the question of whether or not, last two lines of 69, whether persons concerned qualify for a right of residence in that member state under national or international law.
Sorry.
So sorry, page 289. So the court was asked by the National Court, as we see at paragraph 69, the last two sentences concern the case where the person qualifies for a right of residence in that member state under national or international law. And the chosen answer of the court was, well, not where you qualify under a provision of secondary EU law. And my submission, that is simply an application of the principle that a superior EU law right to reside excludes an inferior EU law right to reside. It is a question of the internal construction of European Union law.
So is the court not answering the question as it was posed?
The court is not answering the question about national law, no.
No. Bit odd.
Well, in my respectful submission, I think not for the Court of Justice, because of its question system, it's often asked questions that it doesn't feel the need to answer.
No, I can't now remember the facts, but it was enough, wasn't it, on the facts to answer it in terms of secondary EU law, not national law.
Yes, so NA is the case of a child of a worker at school.
Yes.
So
So there was the derivative right under the schools directive, the Article 12 or whatever it was.
It's under Article 12. It's actually the workers' directive. It's read in as a right, as a consequence of the right of residence of the right to go to school.
It's under a regulation as well, so that's why it's a provision of secondary EU law.
Yes,
And the reason it doesn't answer the question about national law, just to repeat myself, is that on the facts of this case, it's found it didn't need to because it got a sufficient answer from.
yes, quite possibly. But the answer that they give tells us about the internal structure of EU law, and another way of looking at it is as a question of lex specialis. That there was already a superior right that gave possibly more rights, oh, in fact, no, not possibly, definitely more rights than Zambrano. And therefore,
also be true of a provision of national law.
it may be true of a provision of national law, absolutely.
Well, and we need to look at EDA.
Yes.
Because that Mr. Blundell refers to is that relies on as covering the gap that you've identified in.
Yes, but what I take from NA is at least the negative point that the court chose not to say.
Okay.
And I think chose not to say that the rationale for this was that the right under secondary law meant that there was no need for the Article 20 right. It was a question of the hierarchy of EU law.
Well, that's the inference that you draw.
Sorry, my lady, I didn't catch
That is the inference that
Indeed,
you
my
draw.
lord. My lady, it's absolutely my submission.
Yeah.
Yes, indeed. It's not the explicit language of the case.
Right.
Turning then to EIDA and the particular reasoning where the court deals, which my learned friend took you to. So page 218 of the bundle of Divider 7. And the heading at the top of that page, interpretation of Articles 20 and 21 TFEU. And we've just seen from A that the court looks first to Article 21 and the secondary legislation made under it for rights. And we then see again that in paragraph 67, that first of all, the reference there to Directive 2004/38. And then moving down to paragraph 71, there are also very specific situations in which, despite the fact that the secondary law on the right of residence of third country nationals does not apply, and the union citizen concerned has not made use of his freedom of movement, the right of residence essentially cannot, without undermining the effectiveness of the union citizenship that citizen enjoys, be refused to a third country national. And in my submission, it's important to note the framing again. It is about a right of residence cannot be refused. And I do say that's significant, because what I say is that the court is underlining that it is not telling member states what kind of right of residence to grant, but also it is not accepting that the right only arises where there has not been a grant. It is setting a basic principle that it cannot be refused.
But it's premised on the basis that there is no other right of residence, isn't it?
Premised on the basis there's no other right of residence under EU law. And we see that from the opening words of paragraph 71, despite the fact that the secondary law on the right of residence of third country nationals does not apply.
That's
Not, not premised on the basis that no national right arises. And this would be a very, it would have been very simple for the court to say so at that point.
Well, other than the fact that it's talking about a third country national who wouldn't necessarily have a right of residence anyway, under national law.
Well, they may or they may not. But what is significant is that the court isn't in paragraph 71 saying, and it could have done, despite the fact that neither the secondary law nor national law applies to give a right of residence. It's only talking about the structure of EU law, as we see at the heading, interpretation of Articles 20 and 21. And then we see the overall explanation of those cases at 72 in the last two lines, or in the first line of 72, the common element in the above situation is that although they're governed by legislation which falls a priori within the competence of the member states.
Sorry, where are you reading from?
So, sorry, paragraph 72, bottom of 218. A common element in the above situations is that although they're governed by legislation which falls a priori within the competence of the member states, namely legislation on the rights of entry and stay of third country nationals outside the scope of Directives 2003-109, 2004-38. Pausing there, 2003-109 is the directive on long-term residence of third country nationals, so it's not about free movement. And 2004-38 is about free movement of EU citizens and their family members. So the court is framing this as cases that fall within the competence of the member states' legislation on the right of entry and stay. And then it says they nonetheless have an intrinsic connection with the freedom of movement of a union citizen, which prevents the right of entry and residence from being refused. So what the right that's being canvassed by the court there is a right to prevent a right of residence and entry from being refused. And our submission is that when the member state grants a right of residence of any quality that complies with the principle of the Zambrano right, it is complying with the principle of the Zambrano right. But it is not destroying or disappearing or ending that right. The right does not come and go. It exists to prevent the refusal. And then the court sets out case why EIDA is not such a case. The first point it makes is, in short, this isn't a Zambrano case. He's not in the same state as his daughter. Secondly, he can't show that historically his situation has had any effect on the EU citizens' rights, his daughter's or his spouse's rights. Obviously, the effect on his rights not being self-sufficient. Finally, so these are cumulative in my submission, the claimant has a right of residence under national law which is prima facie renewable and which can in principle be granted the status of long-term residence within the meaning of Directive 2003-109. So coming back into EU law, not the situation here, in Akinsanya's case. And in those circumstances, and the circumstances are therefore threefold, it cannot be validly be argued that the decision at issue is liable to deny the genuine enjoyment of the substance of the rights referenced noticeably to McCarthy, the case of the dual national Irish-British citizen in the UK, not a Zambrano case. And then the court explains itself further by referring to a purely hypothetical prospect of exercising the right of freedom of movement. And in my submission, that's when one steps outside of the parameters of the Zambrano jurisprudence, where it is purely hypothetical. And that is why the Secretary of State implemented the Zambrano jurisprudence, as Mr. Justice Mostyn accepted, by excluding only those with indefinite leave to remain. Only they, in terms of leave to remain, were purely hypothetical. So in my submission, this is not a case of gold plating. It's not a case in which the state has provided for purely hypothetical cases of expulsion. If the state had recognised the right to reside for people with indefinite leave to remain, people who could under no circumstances be expelled, denied a right to work, or denied social security benefits, that might, on my submissions, would have been outside the realm of EU law. It would be the exercise of some other power. But my learned friend doesn't argue that this provision is ultra vires, Section 2 of the European Communities Act. He doesn't say it's not the implementation of EU law. He says it's gold plating within the ambit of EU law. And I say it's just as the United Kingdom's implementation of the Zambrano principle. And can I just, and I appreciate that your Lordship's dealt, it was addressed relatively shortly, the interpretation point this morning, but I want to just take your Lordship back to the language of Regulation 16 and the explanatory memorandum, because I say that all of this is consistent with my submission. The Secretary of State considered she was implementing EU law. So page 25 of the bundle, the current version of the regulations. Well, in fact, sorry, can I ask your Lordships, I apologise, leaving around. Can I ask your Lordships just to go back to the original pre-amendment version, which is page 15. I just want to show your Lordships what the Secretary of State was doing when she introduced the Zambrano rights, doing textually. Page 15 of the authority bundle, tab 2, we have the pre-amendment version. Our learned friends has explained that this had already implemented Chen and Teixeira and Ibrahim. So it had already implemented some derivative rights. I could ask your Lordships to look at paragraph 1. There isn't a definition of exempt person in this version. So paragraph 1 is the only exemption. And the exemption is stated there in paragraph 1, a person who's not entitled to reside in the United Kingdom as a result of any other provision of these regulations. So those are the free movement provisions. I say that's respecting the hierarchy of EU law. Now, if we then look at the amendment, which is at page 5, see in the middle that a new regulation, Regulation 5A, is being amended. And at Regulation 3, sorry, paragraph 3A, middle of page the words I've just read to your lordships are deleted and replaced by an exempt person. If your lordships will now look down at the new definition of exempt person at the bottom of page 5, we see the first of those categories, Roman 1, is the original category. So the Home Office has added, or the Secretary of State has added 3 new categories of exempt person when she implemented the Zambrano provision. The first of those is the person who has a right of abode, which is an even more secure status than indefinite leave to remain. The most secure status short of British citizenship. The Section 8, which is persons who are exempt, for example, as diplomats. And then over the page, the new provision, who has indefinite leave to enter or remain in the United Kingdom. Now, when we then look at the explanatory note on the next page, we see that that paragraph 3 is explained as giving effect to Zambrano. So the author of the explanatory note is recognising that the creation of a new class of exempt person, but limited to the 3 that I've just described, was implementing, was giving effect to, my apologies, giving effect to the Court of Justice's decision in Zambrano. And in my submission, there's nothing wrong with that. And what the Secretary of State did in terms of the test, if we just turn back to the new paragraph 4a in page 5, paragraph C, which is still expressed in essentially the same language, we see...
Sorry, where are we looking?
Page 5, the new paragraph 4a, letter C of the new paragraph 4a, we see a condition on a premise would be unable to reside if he were required to leave. And in my submission, that is a legitimate implementation of the Zambrano principle. The Secretary of State was not required by EU law to limit the recognition to cases where he would be required to leave now or tomorrow, whether by being denied leave to remain or being deported or being denied a right to work or some other situation. She didn't have to deal with it in that way. She was entitled to implement it in this way. And that may mean that there are some cases where, on a different national implementation, the person could lawfully have been expelled. But to hold otherwise is to say that there is a single true way of implementing the Zambrano principle in the 27, I think it was at that stage, 27 states, EU states, to which the principle applied.
Mr. Cox, can you help on one small thing? In the preamble or introductory words to the 2012 regs, page 3 of the bundle, and similarly 2016 regs, page 18, it says that the Secretary of State made the regulations in exercise of the powers conferred by European Communities Act 1972, section 2.2, well, we know what that is, and of the powers conferred by section 109 of the Nationality, Immigration and Asylum Act 2002. What is that power?
From memory, that is the power about appeals. And so it relates to Regulation 5, which is at page 6.
Right.
Which made a separate set of amendments.
I see a nod from the other side.
If it assists, yes.
Thank you. Thank you very much.
So, and I'll draw your lordships to one last feature of the regulatory scheme as it now is. Page 26. And it's the different language in the route for the children of Zambrano carers. Paragraph 6 of Regulation 16, the criteria there are that the person is under the age of 18. Skip out B for a second. The person's primary carer is entitled to a derivative right to reside, and the primary carer will be prevented from residing in the UK if the person left the United Kingdom for an indefinite period. So far, so identical to paragraph 5. But B, the person does not have leave to enter or remain in the United Kingdom until 1971. So here the Secretary of State has chosen a different approach to implementing rights within the scope. Looked at it differently. These are matters of legislative policy for the state.
Okay, but why?
I don't know why, my lord. But I don't argue it's... but I argue that it sheds light on the fact that this is a legislative exercise in terms of the giving effect of the treaty. It is not a judicial exercise, and it is not an exercise that needs to give a particular official a duty to decide each aspect of compulsion. And what the Minister essentially invites this court to do is, and we don't shrink from it, we said it in the skeleton, is to amend the regulation because she's changed her mind about what she wants it to mean. Now, there are situations in which this court can do that, can enforce an ambulatory construction on a measure implementing EU law. And they are, as my Lord the Vice President mentioned in discussion with my learned friend, a conforming construction where to do otherwise would be to breach EU law. But my learned friend doesn't argue that there's any breach of EU law here by Mr. Justice Mostyn's judgment. And so, in my submission, it does raise, in that sense, a constitutional question. But what the Secretary of State is doing is saying that, or what, in order to succeed, what she must do is to show that there is only one correct way of implementing EU law. And she hasn't done that. That's not to say she can't amend the regulation. She may be able to amend the regulation if it meets other requirements of law and policy and practice. What she can't do, in my submission, is have this court create
You
an...
can't actually amend the regulation because it's no longer in force, but you mean, hasn't it come to an end?
She may be, I mean, I don't want to speculate, but...
But surely, what would... The problem is with the rules. She can change. This problem can be met by changing the rules, can't it? But she's got to understand what she's doing.
She's got to what she wants to understand, and we support the invitation to the court to help her understand it, is did she step outside of the parameters of the Zambrano jurisprudence in this?
But I think, as you acknowledged, she's created this problem for herself through perfect honesty by saying what I was intending to do was to give this EU settlement right to Zambrano carers, as previously recognised by the EU law and Regulation 16, which implements the EU law. She could say, and you acknowledged this early on, well, actually, I don't want to give this right to all Zambrano carers. In fact, we're told early on she wasn't going to, but she eventually decided she would. I forget where I got that from, but I think that's in the evidence somewhere. Actually, I would like to give them only to some Zambrano carers. That, subject to various possible arguments which don't bear on this, it was perfectly within her rights. She's the rule maker.
Yes. Subject to arguments about fairness and retrospectivity and equality.
So her way out of this is not by amending Regulation 16, which anyway isn't in force anymore, I don't think, but it's by taking a different approach to the Appendix EU. What
Regulation
it says she's
16
setting out to do.
Regulation 16 is still in force for persons who made applications under the settlement scheme that have not yet been finally resolved, either by the Secretary of State
Oh,
or...
I see.
or
Okay,
the-
well, in a sense, that doesn't matter. It's
I just
in force or
wanted to-
not. But am I not right that if once we have said what the content of the Zambrano principle is, and or if different, what the effect of Regulation 16 is, she can, in looking at Appendix EU, say, okay, now I understand that, I don't want to replicate those. But that's not what she said, and that's why we're here.
So the content of the parameters of the Zambrano right do not dictate the rights that she must now give to persons who fall within those parameters.
You're just restating what I put to you.
Trying to.
Yes, it's fine, but you agree.
But in a way that means that I'm sure that it's what I agree with.
I'm saying we've got enough to grapple with in this case without predicting what challenges might be made to future amendments to deal with other cases where retrospectivity argument is raised and so on.
Well, it is possibly this case, but certainly the issues that were dealt with below are both narrow and demanding enough to occupy this court's time.
But both of you have in different ways, but you in particular, tried to sort of set out why all this matters and what the implications are. But I mean, so has Mr. Because he said he wants to know the answer to round one, even if he loses. He wants to know the answer to round one because it'll inform the Secretary of State's thinking, deciding what to do next. But
might I just quickly finish on the interpretation points? So the explanatory memorandum doesn't say anything about limits.
we're certainly allowed. Sorry, I'll let you go first.
No, it's the point that my Lord Justice Bean made early on. It basically begs the question because it doesn't say how they're going to implement the Zambrano rights. It simply says we're implementing the Zambrano rights.
Yes, and one can see a potential audience for it, which is the European Commission. It says, "Hey guys, it's been 18 months since the judgment, but look, here we are, and look at our regulation. That looks good." And certainly, there's no evidence that the European Commission ever raised any queries about the meaning of about the implementation. And in contrast, I think really just for your Lordship's and my Lady's notes, Energy Solutions, the judgment of Lord Mance, particularly at paragraphs 34 to 35 and 39, which are at pages 564 to 567, show, one, transposition guidance is not an aid to the construction, generally or specifically, of regulations. My learned friend's submission to the contrary is, in my submission, contrary to principle and unconstitutional. Courts are not told how to interpret law by the Secretary of State issuing some general guidance. Two, the need, the avoidance of gold plating, if that is what it is, it can be discerned in specific cases from the admissible material, namely the explanatory note, the explanatory memorandum, and if it exists, an impact assessment. And that's paragraph 35 of Energy Solutions. But you will see from paragraph 34 of Energy Solutions the kind of detailed analysis that you would expect from the respondent to show that gold plating was intended to be avoided. There is no language, which you've been referred to, that suggests that the Secretary of State was trying to give this the most narrow implementation possible. And you have the most important piece of evidence, which is the language of the regulations, which show the contrary. in the Nolan judgment, I mean, I think in my submission, both the cases of well, British gas trading, I think, was dealt with in your lordship's question to my learned friend about conforming interpretations. British gas trading tells us that you must have a conforming interpretation to, in the words of the head notes, fulfil entirely the obligations arising under the directive. No one said that this doesn't fulfil entirely the obligations arising under the treaty. The scheme that Lord Mance was examining in energy solutions was one which needed to balance the rights of commercial operators who had suffered a breach of their rights of public procurement and the public authority that they were trying to get damages from. And from that careful analysis in my submission, Lord Mance shows why in that case that the directive was not intended to go further than the Frankovich requirements. But that material doesn't exist here. And USA against Nolan, again Lord Mance in particular, paragraph 14, which is at page 472 of the papers, where a directive, and again here we're speaking of directives, allows a member state to go further than it requires. There is no imperative to achieve a conforming interpretation. By parity of reasoning, in my submission, where a treaty requires respect for rights within parameters, there is no imperative to interpret national law as adhering to one side of those parameters. And that's what essentially the Secretary of State says. He says, wherever there is room for flexibility, you must construe the regulations against the Zambrano claimant. So that's not only why conforming interpretation isn't permissible and a rectifying construction isn't permissible, but why the correct inference from the language and the explanatory memorandum is that the Secretary of State correctly believed she was implementing Zambrano jurisprudence and has been following that and followed that approach for 8 years. Might have a moment. My Lords, those are our submissions. We'd invite you to dismiss the appeal on both of the grounds.
Thank you, Mr. Cox. Yes, Mr. Cox.
My Lord, my Lady, just 3 very short points in reply, if I may. The first one, early on in his submissions this afternoon, Mr. Cox referred the court to the European Policy Scheme guidance, which is in the authorities bundle behind tab 21 at page 691. Can I just make clear what that guidance is? This is internal guidance to junior caseworkers. You'll see it's dated the 12th of December 2012. Is therefore in my submission no aid to construction at all. That's the way in which it's seeking to be used by Mr. Cox to the amendments made in November 2012. It postdates them, and it's internal Home Office guidance for junior caseworkers. No more and no less than that, but not an aid to construction.
Yeah, but you don't attempt to suggest that there isn't an inconsistency between
no,
10 and...
my Lord, that would be impossible for me. Obviously, there is that inconsistency. I'm faced with an inconsistency, whichever way I cut the case, because there is the wording of the regulations, which I can't escape. What I've sought to do is to explain that's inconsistent with what the Zambrano principle is actually about, and suggest that the court does have the powers to remedy that. But no, I accept that entirely, but it's not an aid to construction. And obviously the aid to construction, I've shown the court contextually, the explanatory note and explanatory memorandum. You have my submissions on that, I don't seek to repeat them. The second point, just to clarify, and it's really a point I made this morning in my submissions, but it came up again this afternoon. Of course, an individual who has a right to reside but not a right to work doesn't need to be given a right to reside to comply with Zambrano. If in fact they would be compelled to leave because of the absence of a right to work, then it is open to the Secretary of State, as I indicated, to remove any prohibition on the grant of work. The way that my Lord Vice President put it this morning in summarising effectively that that which is not expressly prohibited is allowed, that is correct. But that's all that will be required in a particular case. And I've informed over the lunchtime adjournment that the example I gave, which I think has been developed, of, for example, somebody who couldn't be returned because of an Article 3 situation in their home country, so gets rolling discretionary leave, that would be a good example of somebody who ordinarily would be here on a very, very narrow basis. They would be here under deliberately harsh conditions. It's been recognised in the cases. So they wouldn't have a right to work. They might have a no recourse to public funds condition. But if they found themselves with, for example, a British citizen child that they were a primary carer of, they could, in principle, ask for a right to work, but they wouldn't be getting a right to reside. That simply wouldn't be necessary. So that's the second point. Well, the third point is just to pick up on one of the final submissions that my learned friend made about the transposition guidance. Just for the avoidance of doubt, the transposition guidance, the guidance on gold plating, that we've referred to on our skeleton argument, we don't refer to as an aid to construction. What we used it for was to show that there is a process the government uses when it intends to gold plate. And of course, my learned friend has taken you to the Energy Solutions judgment and various passages there. What you also have in that judgment, as we indicated again in the skeleton, is paragraph 39. This is behind tab 16. Paragraph 39 of the judgment of Lord Mance.
So where are we?
So page 566 behind tab 16 of the authorities bundle. It's Energy Solutions in the Supreme Court. And paragraph 39 at the bottom of the page, he says, 4 lines down, although there's no more leasing imperative to construe the scheme so far as is possible consistently with Frankovich conditions, it is, I think, a natural assumption that the UK legislator will go no further than required by EU law when implementing such a scheme without considering this and making it clear. So that as a principle of construction derived from Energy Solutions is completely consistent with the transposition guidance and gold plating guidance. And that's why I took your lordships and your ladyship to the explanatory notice and explanatory memorandum to show that actually where detail was given as what was intended to be done, what was used was the language in effect of force and compulsion. So very much the analysis of Zambrano we say now is correct. What wasn't done was any indication that there was an intention to go further. And of course, the reasons I explained this morning, if my learned friend were right, then in effect what the regulations would have done is to create a right which can't coexist in the way anticipated. But my lords, my lady, I've made those submissions already. I don't seek to go over old ground in that sense. I'll just turn my back for a moment to check there's nothing else. My lords, my lady, again, I'm very grateful for the extra time this morning as well. Those are my submissions in reply.
Well, we're grateful to both counsel for...
My lord, some matters arose in argument, and I wondered whether or not the court would wish the parties or party to provide any notes.
Well, I was just thinking that just before you rose, the point I'd reached, but my lord and my lady may be in a different position. Now we've got the whole argument before us. I don't think any of the matters that came up are such that we need any further materials. That's their view as well. So thank you. If that was going to be an offer, it's politely declined. The usual procedure will be followed. Risk of spelling out, which you both know very well. We will reserve our decision. Draft judgments will be circulated in due course with a view to the parties agreeing the terms of any consequential order, or if they can't agree them, providing brief written submissions so that we can decide the consequential points at the same time as we hand down the judgment, which the parties, of course, need not attend, even assuming it happens in open court, which it probably wouldn't in any event. And of course, the other purpose of pre-circulation is so that you can draw our attention to any typographical or other minor factual errors. Thank you both again.